Welcome, everybody. My name is Nancy Lopez. I'm on the board of directors of DC Refers, and I am so thrilled to have you all here today for Doing Good and Doing Well, the Ethics of Low Bono Practice. We are fortunate to have as our speaker, Charlie Lemley. He is senior counsel at Wiley LLP. His practice focuses on professional liability in the insurance group. He has a long list of cases that he has tried, argued, and won. And I will put a link to his bio in the chat so you can see the breadth and scope of all of his many professional accomplishments. Charlie is also a teacher. He's an adjunct professor of professional responsibility at George Mason University. He coaches mock trial teams, helping law students to hone their courtroom skills. He has been faculty at Washington Council of Lawyers litigation skills trainings, and is just a fantastic instructor and teacher of legal issues. Finally, Charlie is the chair of the board of directors of DC Refers. DC Refers is an online referral service of lawyers and mediators who offer reduced fee services to clients of modest means. Those three things, being a lawyer, a teacher, and chair of the board of DC Refers, make Charlie the perfect speaker for our program today on Doing Good and Doing Well, the Ethics of Low Bono Practice. So with that, Charlie, take it away.
Thank you, Nancy. That was too kind. It sounded like something I might have written myself. Welcome, everybody. I'm glad to have you here. I'm going to be showing you some slides here in just a moment, and I'm happy to answer any questions as we go along. If you wants to put something in the chat that I think is interesting, but it's good to see all of you, at least virtually. The title of the let me go ahead and put the slides up here to get started. So the title of the presentation is Doing Good and Doing Well, the Ethics of Low Bono Practice. And we're going to talk about what we mean by all those things in a moment. But we're talking about the justice gap today and how to bridge the justice gap. And the doing good and doing well is kind of like the gap is like all gaps. It has two sides. There's a side where there are clients who are desperately in need of legal services. And there's a side where there are lawyers who would love to serve those people if there were an economically viable way to do it. So the doing good part is serving those people as best you can, and maybe at some sacrifice to yourself. The doing well is that it might also be a way for people to expand their practices and find new clients and break into new working areas. So with that, oh, there you go. I'm sorry, I was looking at the wrong screen as usual. I've been not having a good Zoom day, folks. Okay, so I'm going to talk just a minute about the justice gap. You've all heard about the justice gap, and you know, the great Jim Sandman, who I think is one of the greatest lawyers probably of all time. I'm spotlighting that for everybody, except myself. One second. There it goes. Okay. Used to make some great presentations and telling lawyers they needed to develop a sense of urgency about the justice gap. And it worked for me. It didn't work for a lot of other people. And if Jim Sandman didn't convince people, then I probably don't think I can either. So I'm just going to touch on this now. But keep in mind, this is one of many topics that we'll just touch on today that could be the subject of an all-day seminar. The justice gap is very important. There was a 2017 study showed that 86% of legal needs of the poor and low-income citizens got inadequate or no attention. 86%. There are courts in which 80%, 50, 60, 70, 80, or even more percent of litigants appear pro se, totally without a lawyer. That's a sea change from what the case was about 50 years ago. The most common legal problems these people have are what you would expect. They have employment problems, housing problems, consumer debt, insurance, a lot of family law. For people who are at or below 125% of the federal poverty limit, there are some federally funded legal services available by the Legal Services Corporation. In 2020, that meant an individual income of $15,950 a year, or a family of four, $32,750 a year. In the District of Columbia, that's not a lot of money. People just above that line, though, some non-government organizations, some nonprofits will also provide free services to people up to 200% of the poverty line. Others may have other cutoffs. Whatever it is, there are a lot of people above that cutoff line who are equally in need of legal services, equally unable to pay for the legal services under traditional full fair terms, and yet there is no help available for them because they make a little bit more money than the other people. So If you want more data on this, by the way, if you're not familiar with the Justice Gap, the Listening Project report from DC 2016 or 2017 is just fabulous. I spent hours looking at that thing and I barely scratched the surface. And the Legal Services Corporation, if you want nationwide data, the Legal Services Corporation publishes reports every year that are also fabulous. So there's a lot of data available on this. We're going to talk about here are the people between 200 and 400% who have all these same legal needs, but who also can't afford to pay full fair lawyer rates and traditional full-blown representations, but they have no free help. They don't qualify for free help. So we have massive unmet need for legal services on one side, and we have lawyers. We have a lot of lawyers, and there are lawyers available to provide services to people who to whom they can economically viably do that. And the Legal Services Corporation and many courts around the country, many bar associations around the country who have studied this issue have recognized that offering legal services at substantially reduced rates and under alternative terms and conditions might permit lawyers to bridge that gap, to serve those people, to give them the legal need that they help, and also to build their own practices, maybe not at the rates that they would like to charge, but at rates that can keep the lights on, and let them do a valuable service while also building their practice. Right now, roughly 3/4 of the legal profession works in firms of 5 or fewer lawyers. I'm going to show you on the next slide. Those people are just as public service oriented. They're just as desirous of being able to help their fellow people. They want to serve the profession, want to serve the community, but they often can't afford to take on big pro bono matters. You know, a big law firm can take on a pro bono matter that might require 500, 1,000, 2,000, 4,000 hours of lawyer time, and just sort of spread that out amongst the lawyers in the firm, and it's doable. Somebody who's a solo practitioner, if they take on a pro bono matter that's like 400 hours of their time in a year, that's a big hit. They're basically a dollar for dollar loss. It's not easy for them to do. And so what we're talking about today, we're going to talk briefly about DC refers at the end, is a way for lawyers to discharge their ethical obligation to do pro bono work without completely sacrificing their income and the revenue of their personal income or the revenue of their small firm. Here's just a chart that I snatched from a report online. I'm not vouching for these numbers, but what struck me about this chart, the reason I cut out and pasted it here is I expected the numbers on the right to be much, much larger than the numbers on the left. Not because of the people involved, but just because of the economic realities. Over on the right, you have the average pro bono hours of lawyers at firms of various sizes. On the right, you have firms of more than 300 attorneys. All the way on the left, you have solo practitioners. In the middle, you have, all the way from 2 to 5 attorneys up to 101 to 300. By and large, these people in the 1 attorney and 2 to 5 attorneys, even 6 to 10 attorneys, when they do pro bono work, that's a real sacrifice. I mean, it's an hour for hour sacrifice. It's an hour spent on a pro bono case means either an hour's worth of less revenue that comes in, or an hour that has to be spent on other things to make up for that lost revenue. Whereas in large part, and I'm not taking anything away from the big law firms. I've worked at big law firms all my life. I'm very proud of the pro bono work that we did at Wiley Ryan and that I did at my law firm Arnold & Porter. It's great stuff, and it's essential. But, like I said, often associates are doing this and they're getting at least partial billing credit for it. And whatever loss there is in revenue can kind of be made up by spreading it out amongst the 300 lawyers. So I really applaud people in the solo practitioners, people in small firms who are still doing very close to the same amount of pro bono work as the people at the big firms. So if solos and small firm practitioners are not doing a lot of pro bono work, it's not because they don't want to or because they don't care. It's because they're doing as much as they can afford to do. So that brings us to low bono. And let me just take a minute here to talk about these terms. And these are not well-defined terms. I'll talk about traditional pro bono, and that generally means providing legal services for free and no expectation of a fee, either to people who are unable to afford or for certain kinds of organizations that do things that are in the public interest and so forth. That's traditional pro bono. What we call low bono typically means offering reduced fee services. to people who are generally between 200% and 400% of the poverty line. And those rates are usually somewhere in 40 to 50% lower than market rates, but it depends on the market and where you are. This has been just widely recognized as an alternative for lawyers who just can't afford to donate services, but still want to serve the public by providing legal services to people who can't afford them. Same time, it's been recognized as a means for lawyers to navigate a changing legal marketplace where few people can afford traditional full service lawyers, and many people are appearing in court pro se and handling other legal matters on their own. And you'll see some of these people are people who would have been like the bread and butter of many small practices 50 years ago, working class people, very small businesses and so forth. And today they just don't even think about hiring a lawyer as a possibility for them often. So one of these reports that I read said that the number one concern that people had, the number one thing that would help people do more low bono work was to know more about the ethics of low bono work. The TLDR version of this says that it's pretty much, by and large, with a few exceptions, it's the same ethics issues that you have any other time. There's not a big difference here. So if you have no time to watch the rest of this and you're worried about the ethical implications of doing low bono work, just go to dcrefers.org and get started, because it's nothing that you haven't heard before by and large. But I did want to point out a few things for you that are interesting and that might be useful to you as you go forward. Oh, let me move myself here. Hang on a second. There we go. So rules of lawyer ethics, going back to the first ones that were enacted back in, I think, the 1930s by the American Bar Association, have always recognized some sort of obligation to address the justice gap, to address the legal needs of the poor. The old Model Code of Professional Responsibility admonished lawyers to accommodate individuals who were unable to pay all or a portion of a reasonable fee. And I remember I should have put this quote in. There was a great quote about how we are the people who are charged with the administration of justice. And if we have to do that without a fee or at a much reduced fee, then we're obligated to do it. But in 1961, the ABA cautioned that to be careful. We have to be careful that we don't let inadequate compensation result in a decrease in the quality of service. And since the ABA made that comment, many people have studied that issue and have concluded that there's just little to no correlation between reduced fees and reduced quality. And indeed, there can't be, because one of the things we're going to talk about today is that the same rules of competent representation apply to low bono representations or pro bono representations or to full fair representation. So today we have rules of ethics that try to balance those considerations, try to balance the need to serve people, both people of very low income and people of more moderate income, 200, 400% of the poverty line, but also to maintain quality and maintain the reputation of the profession by encouraging pro bono and low bono representations, but still subjecting them to the same standards of competence and diligence. And all the ethics rules now do recognize the importance of lawyers doing something to address the justice gap. And the reason I talked to you about the traditional pro bono and the low bono earlier is because what we're calling low bono is pro bono work. It is defined as pro bono work under most of the rules in the country. You all know the ABA creates some model rules of professional conduct, and they put a lot of work into that. They have committees that work tirelessly on the rules and amendments to the rules, but the rules aren't the law anywhere unless they're adopted there. And if I believe in some form with caveats and modifications, I believe the model rules of professional conduct have now been adopted in all 50 states. I used to teach, it was all but 4 states, and it was all but Massachusetts and California. And I'm pretty sure that those have come around now. So I think all 50 states have adopted the rules, and yet they all put their own little twists and tweaks on the rules so that you have to go look at the applicable jurisdiction if you want to know the content of a specific rule. So the model rule of professional conduct 6.1 recommends that all lawyers devote 50 hours per year, or at least 50 hours per year, of pro bono service by delivering legal services at no fee or a substantially reduced fee to individuals. So that's low bono and pro bono are both defined as pro bono services. But the ABA rule goes on to sort of prioritize services given at no fee. It says that the lawyer should provide a substantial majority of the 50 hours without fee, if possible. On the other hand, if people can't afford to provide 50 hours or a substantial majority of the 50 hours with no fee, they can still serve their pro bono obligation by doing low bono representations. So the DC rule of professional conduct is one of many that also defines pro bono to include providing legal services at a substantially reduced fee, but has no caveat, no prioritization for traditional pro bono services. And that's the case in many states. I've had to look at how all the various jurisdictions, in how they incorporated model rules before, what changes they made many times. And this is one of the few times I've seen what I saw here, which is they really are two competing versions of the rule that have been adopted almost 50-50, just almost by an equal number of states, and with a few little outliers doing their own things. So a lot of jurisdictions do as the ABA model rule does, just adopt it as it's written, and with a slight preference given to free legal services, but still defining pro bono to include low bono. And you can see the list there, and I hope you'll have a copy of this later, so I'm not going to read through the list for you. Other jurisdictions like DC have tweaked the rule to recognize low bono as pro bono work with no preference at all. In fact, many of them also include making donations or otherwise supporting legal aid organizations, which is a great thing. If you're going to support a legal aid organization, that's a good day's work. They think people who dedicate all or a large portion of their career to serving the legal needs of the poor, they're heroes of this profession, and we should all thank them and support them. So in Virginia also is like DC, recognizes low bono as pro bono. It uses the term nominal fee. I don't recall there being a definition of nominal fee, but it's basically a reduced fee. And then a couple of jurisdictions have just pro bono rules without really mentioning what pro bono means. So the bottom line is that lawyers and solo practitioners and small firm lawyers, but all lawyers, can satisfy their ethical obligation under Rule 6.1 by serving clients not necessarily for free, but at substantially reduced rates that reflect the client's ability to pay. One of the key ways, there are lots of resources out there on how to do low bono representations, and they identify various ways to do it in addition to just lowering the fees. The key technique that's been recommended for the past 30 years has been using some form of unbundled legal services or limited scope representations. That is a great way for solo practitioners, small firm lawyers to help create a representational model that people can afford to make their services more affordable. Traditionally, once a lawyer was hired for a matter, they were basically the lawyer for that matter for all purposes. And in fact, sometimes for more than the matter they were hired for. They were in for a penny, they were in for a pound. You couldn't say, no, Your Honor, I'm only doing this part of this litigation. You were doing all parts of that litigation and responsible for all of it. And so you couldn't make an arrangement with your client to say, look, I'm only going to do some of this stuff. Some of the stuff you can do yourself because you were ethically responsible to make sure that all that work was done competently. But today, the rules in most jurisdictions provide an ethical way for lawyers to offer limited scope representations to clients, to tailor the representation to the client's needs without having to worry about being in some sort of ethical violation or having a court compel them to continue the representation beyond what they agreed to do and what their client can pay for. And that's a big deal for people, solo practitioners and people in small firms who, they'll take on a case if it's going to take them 50 hours. They're happy to do that, but they can't risk having a judge say, no, I'm not letting you go. You're in here. You're in for the duration. Your jury trial's set for November. So this concept of unbundling or limited scope representations first arose in response to, back in the 1980s, there were some reports about an increase in pro se litigants in courts around the country. The first one, I think, was Maricopa County, Arizona. And the numbers that concerned them at the time almost seemed quaint now, like when the number of pro se litigants in family court had exceeded 40%. It sent shockwaves through the profession, and that would not be shocking today. So a lot of courts, a lot of bar associations, including the American Bar Association, started looking at the new legal marketplace, this marketplace where more and more people were appearing pro se, and it was beginning to be difficult to match the demand for legal services with the available supply. In 2000, the ABA amended Rule 1.2 to expressly permit limited scope representations. Then there was I forget the man's name, but he was a real advocate for unbundling from back in the 90s. And he published this very famous guide to unbundled legal services in 2003, kind of telling lawyers how to use this unbundling to make their services more affordable to more people. Many of these reports, then they've been court after court, bar association after bar association issued reports on this issue, and most of them identified unbundling or limited scope representation as a means to help lawyers navigate the changing legal market, but also help them provide access to justice to people who couldn't afford services otherwise. In 2013, the ABA passed a resolution calling on all practitioners to offer unbundled services as a means of increasing access to justice. So here's how the ABA describes unbundling. It's an alternative to traditional full service representation. Instead of handling every task in a matter from start to finish, the lawyer handles only certain parts and the client remains responsible for the others. And over the past 20 years, courts and bars all over the country have adopted similar rules, have adopted rules to facilitate these kinds of unbundling and have encouraged lawyers to do them, both for the sake of the clients and to help the lawyers kind of figure out how to thrive in the current marketplace. And here's the ABA sort of describing that two-pronged benefit to limited scope representations. It's an a la carte menu. Clients get the advice and services they need, pay a more affordable fee. Lawyers expand their client base by reaching people who couldn't otherwise afford their services. And the third prong, courts benefit from greater efficiency because the people before them actually know what they're doing. Even the self-represented litigants often are doing a better job of doing what they're supposed to do. 2017, the ABA survey concluded that more than 300,000 lawyers performed unbundled legal services that year. So this is not something that's rare. Of those who did, nearly 80% agreed that unbundling lowered the cost of their cases so that more people could afford their services. And nearly 70% said that unbundling allowed them to offer legal services at a more competitive price. So the first bullet point, I think the distinction there was the first bullet point was it allowed them to help people more. Second bullet point was it allowed them to thrive in their practice more. So in 1992, this issue kind of became. That's 2012. I don't know where I got 1992. That's 2012. The DC Access to Justice Commission and the DC Bar Pro Bono program formed a limited scope representation working group to look at the information from all over the country, all the reports, all the rules all over the country, and to come up with recommendations for the best ways to facilitate limited scope representations in DC for clients of low, limited, moderate means. I happen to be the chair of that committee because it was a great committee, a lot of really good members. So over the preceding years, DC courts had sort of been on an ad hoc basis issuing administrative orders that would allow limited scope representations in certain courts under certain circumstances. And it was just a massive, a morass of rules and orders that you really could hardly navigate. It was kind of hard for lawyers to even know, is this a situation where I can do this? And if so, how do I do it? And the DC rules of professional conduct had been interpreted as permitting some forms of limited scope representations, but they didn't do so very clearly. And they didn't provide any guidance to the lawyers. So the committee worked for a year and a half, and made two principal recommendations that were ultimately adopted. So DC Rule 1.2C and its comments were amended to be consistent with the ABA model rule, but with some DC specific tweaks to permit limited scope representations and to give the lawyer some guidance on how to do that. And we got the chief judge of the DC Superior Court to issue an administrative order amending the rules of all courts within the Superior Court to permit lawyers to enter appearances that are limited by date, time period, or activity, or subject matter, as long as they were in compliance with Rule 1.2. In other words, they were limiting them, and the limitations were reasonable under the circumstances. And those appearances, I don't know if many of you probably know better than I that in the DC Superior Court, it used to be very hard to get out of a lawsuit. If you had agreed to represent somebody in one phase of a lawsuit, to get out of there, we had to appear with the client, in person, and sometimes that was hard to do in pro bono cases. These appearances terminate without leave of court, either when the conditions stated in the notice are met, if it's a date time period, or the lawyer can simply file a notice of completion and their appearance will be terminated. So that these rules allow DC lawyers to ethically represent clients in limited scope representations without worrying about being sucked into a much larger representation. So here is the exact quote from DC Rule 1.2c. It says, a lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. And we went back and forth with the Rules Review Committee and others, we being our working group and the Access to Justice Commission, who over whether this reasonable under the circumstances term should be there. Some people didn't think it should be. They thought it was too paternalistic, notwithstanding that reasonable appears in many other rules and every other jurisdiction has adopted it. But finally, the Court of Appeals agreed that the limitation should be reasonable under the circumstances. And what does that mean? Basically, it means that it's not something, the limitation isn't something that would effectively violate one of the other rules. I think is the best way to look at it. You can't, write a really clever brief for someone that cites all sorts of constitutional arguments that somebody really needs to understand in order to argue the case. Say, I'll just write the brief, you write the reply brief and argue the case. There's just no way that's going to work. But other than that, reasonableness, it's pretty broad. What you can do, limitations you can do, as long as you can explain it to the client, and the clients aren't going to be in worse shape because the limitations, because of that representation than they would have been if they just had no lawyer, then it's probably, the limitations are probably fine. Then comment 5 kind of spells that out. You can't limit it to the extent that it would result in an incompetent representation, and you can't take away the client's right to terminate the lawyer and to make decisions regarding settlement. And comment 6 also says it doesn't require that the lawyer have a written, it doesn't require any specifically in writing, but it says the lawyer should, it said it would be prudent to state in writing, first explain all the limitations to the client, state in writing any limitation that they agree on, and provide a written summary of all the considerations that the lawyer had discussed with the client, and then obtain written informed consent to the limitations of the representation. One of the most popular unbundled services is ghostwriting, and I think the things that apply here to ghostwriting would apply equally to other forms of limited scope representations to a large extent. That's where the lawyer drafts something. Usually we're talking about pleadings or motions that are filed in court, but they don't make an appearance. So back around 2000, there came a series of federal court opinions that really castigated lawyers for ghostwriting. The thing to note about those, and I think I mentioned this somewhere in this presentation, they were cases that involved the same serial plaintiff. He just was always filing lawsuits and had some lawyer helping him do it. And so the courts, I think their reaction to the ghostwriting was overly negative. But the bottom line was it was undisclosed ghostwriting. This person was filing these things. There was no reference anywhere that a lawyer was involved. And then they were insisting that the court interpret their pleadings liberally because they were pro se. But nowadays, numerous ethics opinions around the country have confirmed that ghostwriting is perfectly acceptable, although they differ on the extent to which the fact of ghostwriting or the identity of the ghostwriter have to be disclosed. I got some more details on that. First of all, here is the DC form. You probably can't read this, but I want you to see that it exists. If you want to do a limited scope representation in DC, this is the notice of limited appearance. You can get this on the Superior Court website. Just search Google DC notice of limited appearance, and you'll find the notice of limited appearance where you tell the court, I'm entering an appearance, but only for a specific time or for specific purposes. If it's a specific time, then your notice terminates when that time expires. If it's a specific set of circumstances, sorry, hang on a second. My apologies. I have a pump that turns on about once every 24 hours, and it's the 24th hour, apparently. I had to turn it off. Okay, so, but if the limitation is on the scope of the representation, the activities, like I'm only going to represent them in a certain activity, then you just file the next form, notice of completion. And as soon as you file a notice of completion, you're out of the case. It's a big, big difference as compared to what the old Superior Court rules were. And it's a great way to be able to help people without getting stuck in a representation far beyond what you'd anticipated. And you'll find both of these if you just Google sort of DC notice of completion or something. So a lot of federal courts and some ethics opinions early on found that lawyers' failure to disclose that there had been a ghostwriter or who the ghostwriter was misleading or dishonest to the court in violation of Rule 8.4c. Some of those authorities said it would be okay if the pleading said that there had been a ghostwriter. Others said that the lawyer would actually have to disclose their identity. Many authorities all along have cautioned that lawyers can't use ghostwriting or any other form of limited scope representation to hide the fact that they're actually litigating a case. They're actively, substantially participating in the matter without disclosing their identity to the court or to the other parties. I kind of already said what's in the first bullet point and the second bullet point. Most of those, though, the ones that were kind of negative, first of all, none of them ever said ghostwriting was absolutely improper, as far as I can recall. It was ghostwriting without disclosure, and it was under some pretty harsh circumstances. And most of them are older. The trend now has been towards accepting ghostwriting with just mixed views on to what extent disclosure should be required. And here's some examples of that. ABA, this Informal Op 1414 sort of took a mixed view on it. And it said that whether it was proper, whether ghostwriting without disclosure, and again, this would apply to any forms of limited scope representation, without disclosure was proper, would be a fact-dependent analysis, depending on the extent of the involvement. If it was a lot of involvement and it wasn't disclosed, that would be ethically improper. Just helping someone with draft a complaint without disclosing probably wouldn't be. The ABA reversed its position on that in 2007 with the Formal Op 07446. Just flatly said that it's fine, that a lawyer can provide legal assistance to litigants appearing before tribunals pro se and help them prepare written submissions without disclosing or ensuring the disclosure of the nature or extent of such assistance. So that's the ABA's current word on the question. And most courts and bar associations since 2007 have adopted that view. There was a 2018 article where they found that 18 states, including DC, explicitly allow non-disclosure of the ghostwriter's identity. 9 permit ghostwriting but require full disclosure of who did the ghostwriting. 7 require disclosure only when the limited scope representation, the representation itself is substantial or extensive, where effectively you're actually representing the client in full, but you're claiming to be representing them only on giving them advice or something. And 9 require that if it's the pleading is ghostwritten, have to disclose the fact that it was ghostwritten, but not the identity of the ghostwriter. And these say something like, this document was prepared with the assistance of a lawyer. Almost all authorities appear to agree that providing unbundled legal services or any form of low bono representation, lawyers are generally subject to all of the other ethical obligations that lawyers are always subject to. Rule 1.1, competence. Rule 1.3, diligence. Rule 1.4, communication. Communication is one that's really important in limited scope representations because you have to explain the limitations and the potential downsides of the limitations to the clients and make sure they understand. Rule 1.6, obviously, confidentiality. The fact that you're representing somebody at reduced fees or only in a limited scope doesn't change the fact that you have to keep their confidential information confidential. And the conflict of interest rules apply. That's probably the biggest one. If you ghostwrite a pleading for someone, you need to make sure you don't have a conflict of interest because you could be found to be taking a position adverse to the opposing party. And that's the real sticking point for lawyers. If there's anyone that's really important, that's the one. So DC had an ethics opinion 330, and it found that unbundled legal services are permissible as long as the client is fully informed of the limits and the limits don't bar the provision of competent service or otherwise violate the rules of professional conduct. And they specifically noted what I just said a moment ago, that all the other duties apply. Diligence, loyalty, communication, confidentiality, and avoidance of conflicts of interest are the ones that were mentioned in that ethics opinion. Said one question was raised was, well, what's opposing counsel supposed to do if they know that this person is appearing pro se, but that they have a lawyer in the background? Are they supposed to communicate with the lawyer, not directly with the person? It's an important issue in these limited scope representations. And it found that opposing counsel should treat the party as unrepresented unless otherwise given notice. And if you're a lawyer who's going to engage in the limited scope representation, the reason why the limited notice of appearance is so important is that it lets the other side know, here's the part of this thing that am representing the client in. If you want to talk about that issue, contact me. If you want to talk about anything else, you can talk directly to the client. So lawyers on the other side will know what they need to do to comply with like Rule 4.4 and so forth. And the ethics opinion noted there's generally no obligation to disclose the lawyer's identity. Although even that ethics opinion said, make sure you look at if you're in a court other than DC, make sure you look at the rules and case law from that jurisdiction. Case, since Virginia's right next door, Virginia Legal Ethics Opinion 1874 basically did expressly adopted ABA Formal Op 07-446 and quoted it as follows. Litigants ordinarily have the right to proceed without representation, and they may do so without revealing that they have received legal assistance in the absence of a law or rule requiring disclosure. Then they went on to say, for the reasons set out in this opinion, absent a court rule or law to the contrary, there's no ethical obligation to notify the court of the lawyer's assistance to the pro se litigant. So there's no disclosure obligation. Again, they reiterated that other duties apply, including duty of competence and so forth. And like the DC ethics opinion, they noted that whether and to what extent disclosure is required in court depends on the local court rules and authorities. And the same for whether ghostwriting would constitute appearance. There actually, I've neglected to mention, there have been some courts where, I'm not sure this has actually been found recently, but where it's at least been suggested that by ghostwriting a pleading, especially if the lawyer's name was on it as the ghostwriter, that the lawyer would be deemed to have entered an appearance in the litigation. That's nothing. I think you can obviously check the rules of whatever court you find yourself in. I doubt that's ever going to be a problem for anybody. So the bottom line, in DC and Virginia, if you want to do low bono representations, you want to help make your services more affordable to clients, you can perform part of the services for a client, figure out what they really need help with and what they can afford. If they need help drafting a brief, you can limit the scope of representation to drafting a brief. And with these forms they have in DC, and I think they have similar forms in Virginia, I know they do in many states, you can enter an appearance if you want to. There are circumstances where you might not want to and wouldn't have to. You can enter appearance, be the lawyer on the case for that limited purpose. And then when you're done with what you agreed to do, you're not the lawyer anymore. It's really a nice way to be able to help people out without getting bogged down in a long, dragged out litigation with lots of discovery battles and so forth. I wanted to mention this Rule 6.5. There's a model rule and the DC rule. And the rule says, you can see it right here. It says, a lawyer who, under the auspices of a program sponsored by a nonprofit organization or court, provides short-term limited legal services to a client without expectation by either the lawyer or the client that the lawyer will provide continuing representation of the matter, is subject to rules 1.7 and 1.9, and then there's conflict of interest rules, only if the lawyer knows that the representation of the client involves the conflict of interest, and is subject to rule 1.10, which is the imputation rule, where that conflict would be imputed to other people in their law firm, only if the lawyer knows that another lawyer associated with a lawyer in a law firm is disqualified by rule 1.7 and 1.9. And so what all it means is, this rule applies to, I mentioned this because I thought some people might see this, and it is sort of a pro bono / low bono rule. It applies to legal advice hotlines, legal advice clinics. Like I think a lot of us have probably done things with the DC Bar Pro Bono Center and so forth. So it applies to those kind of clinics where you go in and sit at a table and people come in and ask for advice or ask you to help them draft a will or something. That's what they're talking about here. They're conducted under the auspices of a nonprofit organization. And all that's required there requires that the client give informed consent to the limited scope of the representation. Like, you realize I'm only going to draft this will for you. I'm not going to probate it or anything, which you would do anyway. The limitation has to be reasonable under the circumstances. And where appropriate, if somebody comes in and says, I need help with this, and you realize there's not, whatever we do here, you're going to need a lot more help after this, then you need to advise them of that. But it also says if you want to do one of these things, you don't really have to check for conflicts. And you don't have to worry about inadvertently inadvertently taking on a conflict of interest because you didn't realize that somebody at your law firm represents the party that's trying to evict this person. It just recognizes that you really can't check for conflicts under those circumstances. And so it limits conflicts of interest to those that the lawyer actually knows about while they're at on the hotline or at the advice clinic or so forth. So it's just a nice rule for people who want to do that kind of thing. And I wanted to put it in here because everything else here really applies to low bono, pro bono, whatever you want to call it. And I just thought this was an interesting rule, one that people need to know about if you're thinking about doing public service things. So doing well while doing good. So how do you do this? Lawyers have learned to do low bono practice on an ad hoc basis, but some have also learned to do it as a living. The Law School Consortium Project was founded back in 1997 and helped a lot of law schools develop infrastructure that developed what they call incubators and so forth to support their students going forward as solo and small firm lawyers developing low bono practices. Lots of these incubator programs have helped young lawyers get started in the business and build their own practices. Some law schools have actually even subcontracted with recent grads to provide reduced fee services to underserved populations. I think the DC Affordable Law Firm might be an example of that. And there are now many small firms that either were or were not developed through one of these incubator programs that really focus on low bono representations as a business model, as a way of doing their business, of doing good and doing well. And here's just a few examples I found on the internet of people who are advertising, we are a low bono law firm. That's what we do here. Our rates are tailored to your income. So doesn't have to be limited to a public service and a sacrifice. And then in DC, we have DC Refers, and DC Refers was part of a long, thoughtful process. It was founded by Andrea Furster, who's a former president of the DC Bar, and while she was president of the bar, this was right after I had done the thing on the rules, the committee on the rules, and they looked at this problem of low bono representations, the justice gap, specifically with respect to people of not quite so limited means. And DC Refers was the result of it. It's very thoughtful. And it's basically a database of qualified attorneys who have agreed to represent people of modest means, people between 200 and 400% of the poverty line at below market rates. And we screen the people, and they apply. They apply. It's like a $50 application fee. We check their references and basic screening, and then they are listed on our database, and clients find them through the database. Here are the poverty guidelines. If you need them, like I said, I assume you'll have a copy of this if you want it. The numbers look a lot different than they did a few years ago, but family of four, 200% of the poverty line is $55,500 a year in DC. That's considered to be far more than you need to be able to afford a lawyer. Most of us couldn't easily afford a lawyer. $55,000 for a family of four, it would be almost impossible. Here are some of the practice areas that we have on the DC Refers, among the DC Refers panel lawyers. At the time we did this chart, which I don't remember exactly which presentation I stole this from, DC Refers had placed 284 cases and given brief advice to 1,072 people and received 2,364 requests for assistance. So that's a lot of people who were helped who would not have had lawyers otherwise. And we want to do a lot more. Here's just some DC Refers by numbers. You can look at those. Here's our most common practice area request. The people who come on our database looking for help, what are they looking for? Family law, you might have expected, is the biggest one. Employment law is the next biggest one. Let me see. Estates, wills, and so forth. Businesses. People who want to get started in a business and so forth. So a lot of these big ones. I'm trying to figure out what this one is. Landlord tenant, yeah, as you would expect. Here are the different ways that we sort of do outreach and help clients find the DC Refers directory. Lots of referrals too. If you know anybody who's looking for a lawyer and they're people of limited means, send them to DC Refers, just dcrefers.org. It's very simple. We have two of the greatest technical people in the world. It just it boggles my mind every time we have a meeting with them that they are helping us build this, and it's really a very high quality, well done database, and they're constantly improving it. So if you are interested in joining our panels, I didn't even mention we also have a mediator panel. That's really something we're just getting started. Not really sure how that's going to go because people aren't familiar enough with mediation to know that to go look for a mediator. But for people who either they're referred to mediation or they just conclude that they might be better off trying with mediation first before trying with a lawsuit, we have a mediation panel. So if you want to join one of the panels, particularly the lawyer panel we'll talk about, you have to be a member in good standing of the DC Bar. Or the appropriate federal forum. I think DC Bar is probably going to be it. You have to have some malpractice insurance. That's the one question we get the most, I think. It would be nice someday if we could offer malpractice insurance for these representations, but it's just not possible now. To have at least 2 years relevant experience in DC and in the practice area where you want to be listed. You have to agree to provide services for a reduced fee of between $75 and $150 an hour. And agree to the DC refers lawyer qualifications, and then submit an online application, and it's a $50 fee. But you do all that, we will handle it very quickly, and love to have you on the panel. Just some snapshots of our website. Again, this is constantly being updated and improved, but this is generally what you go. Somebody comes in, they put in their zip code, and they can, if they want to, they can see if they qualify for reduced fees. What do you need help with? And there's a little simple identification of various kinds of cases. I didn't do a very good copy of this, but you got family law and litigation, housing law, so forth. And then here's where, once they've sort of identified a big picture area, they try to kind of drill down. It's just a way you can, if you ask somebody how to tell us what your legal problem is, the listening project and all other reports like that have identified the bigger problem is people don't know that they have a legal problem, much less what kind it is. So this just kind of helps them drill down to a level of specificity that will help us direct the database, direct them to the right person. Any court appearances, the lawyer needs to know that right off the bat. Brief description of the problem, and then here's what they get. They get some of our lawyers who meet their requirements. And we have great lawyers on our panel, really, really, truly great lawyers. A lot of people who you would know of, people who are leaders in the community. And they're doing this largely for service, but also because, you know, and for many of them, it fleshes out the practice a little bit. So if you want to join our mailing list or otherwise connect with us, we have some great, Nancy Lopez puts on a great DC Refers Connect or Reconnect. Oh my gosh, I'm drawing a blank here, but it's a great, it's a series where people come on and it's like 30 minutes of some interesting person talking about something interesting in the law. If nothing else, it's worth getting on our mailing list for that. Follow us on social media or just contact us or come find us at dcrefers.org. If anybody has any ideas or suggestions or questions, I'd be happy to hear them. But otherwise, I think my time is up. Nancy, would you like to kick me off?
I'm going to give people 1 or 2 minutes if they want to put a question in the chat, just in case.
Okay.
But thank you so much. There was so much information and so practical and helpful. All of the different logistics of limited scope and the ethics rules and how all of this comes together.